All right, this is Dr. 251162FH, people of the state of Michigan versus, is it Regina?
No, then you're on.
Oh, this is those, I'm sorry.
This is Alberto.
Okay, it didn't look like Regina. All right, well, let me get back on his file now. This is docket 25288FT, people of the state of Michigan versus Alberto Herrera Perez. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Alberto Perez, who is standing to my right.
All right, sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you, and put your hand down. And sir, have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
Yeah, but I'm not taking.
Okay, so by not being on medication, does that interfere with your ability to understand the court or your attorney?
No.
All right, so you're feeling fine today, sir?
Yes.
Have you had enough time to speak with your attorney?
Yeah.
All right, and I understand this is going to be a plea today, is that correct?
Yeah.
And do you still live on Waverly Road?
No, Your Honor, he has an address that we've listed on Rysdale.
Okay, I do see that. Okay, we'll make sure that gets in the computer. And who do you live with, sir?
Yeah.
Who do you live with?
Oh, my girlfriend.
Okay.
Daughter.
And are you employed?
Oh, not right now.
Okay. So is she helping support you?
Yeah, my brother does. We own a towing company.
You own a,
No, my brother.
Can you repeat that?
He
Oh.
owns a towing company.
Towing.
okay,
So,
and
What's
a towing company.
brother.
And so is she helping to support you? And he said yes,
No,
and that,
I said no. My
No.
brother.
Your brother is?
Yeah.
Okay, got it.
okay.
Okay, so you're going to be pleading today. Were you on probation, parole, or bond conditions on another file?
No.
No? Okay. And are you a US citizen?
Yeah.
On behalf of the people, what is the plea agreement?
Yes, Your Honor. The defendant will be pleading to count 1, police officer fleeing in the 3rd degree. Upon successful plea and sentencing, count 2, resisting obstructing a police officer, and the habitual 4th offender status will be dismissed. There is also a kilogram agreement to 12 months upfront.
To serving 12 months up front?
12 months jail.
Cap, so a county cap,
Yes.
okay. All right. Is that full, fair, accurate, and complete?
Yes,
All right, and you're waiving count 2 and the habitual 4th?
yes.
As to count 1.
Yes, Your Honor. People of the state of Michigan versus Alberto Herrera Perez, State of Michigan, County of Ingham, in the name of the people of the state of Michigan. The prosecuting attorney for this county appeared before the court and informs the court that on the date and at the location described below, the defendant in count 1, police officer fleeing 3rd degree vehicle code. On or about January 31st, 2025, at North Martin Luther King / West Oakland, Lansing, Michigan, 48915, Ingham County, State of Michigan, the defendant being the driver of a motor vehicle to whom was given a visual or audible signal by hand, voice, emergency light, or siren by Jake Ellis, a police officer, who was in full uniform, and the officer's vehicle was identified as an official police vehicle, acting in the lawful performance of his/her duty, directing the defendant to bring his/her motor vehicle to a stop, did willfully fail to obey that direction by attempting to flee or elude that officer in an area where the speed limit was 35 miles per hour or less, contrary to statute. This is a felony that is punishable up to 5 years and or $1,000. The Secretary of State shall suspend the license for 1 year, per MCL 257.319. Court shall order law enforcement to collect DNA identification profile sample before sentencing or disposition, if not taken at the time of arrest, and against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read?
Yeah,
So you understand count one, police officer fleeing third degree under the motor vehicle code is a felony punishable by 5 years and or $1,000, and the Secretary of State shall suspend your license for 1 year.
yeah,
And it looks like you signed the advice of rights form. Did you read it before you signed it?
Yeah.
Did you understand what you read?
yeah,
And if you had any questions, your attorney was able to answer those?
yeah.
As to count one, police officer fleeing under the motor vehicle code, third degree, how do you plead?
Yeah, yeah,
I'd say out loud.
yeah,
You're changing your plea from not guilty, are you changing it to?
guilty, no?
Yeah.
Guilty, okay. And sir, did anyone force, threaten, or coerce you to plead?
No.
Did anyone promise you anything that caused you to plead? And you understand you have to tell me that now, because if you tell me that later that you shouldn't have pled, I don't have to allow you to withdraw your plea.
Yeah,
And you decided to plead after you spoke with your attorney?
Yeah.
And you've been satisfied with the representation of your attorney?
yeah,
And do you understand that if you choose to appeal now, you first have to ask permission of the Court of Appeals to appeal, and had you gone to trial, then you would have an automatic right to request an appeal and have that be granted, but now it becomes a decision of the Court of Appeals. Do you understand that?
yeah,
Now, if you violate the law or bond conditions between now and sentencing, I do not have to honor the county cap. I could send you to prison if I wanted. However, if you honor everything, and I did more than the county cap, I would allow you to withdraw your plea, and this matter would again go to the pretrial stage. Do you understand that?
yeah.
Okay. Did anyone tell you what I will do at sentencing other than the plea agreement?
She's just asking if we've talked about anything that she might sentence you to definitively at sentencing. Have I said that she has said what she will do at sentencing yet?
No.
And that's because I don't know. I'll make up my mind at sentencing. Do you understand?
Yeah,
Okay. Now, sir, did this offense occur on or about January 31st, 2025?
yeah,
In the city of Lansing County, of England, state of Michigan,
yeah,
at a specific location known as North Martin Luther King and West Oakland, you came in contact with law enforcement?
yeah,
And you were driving a motor vehicle?
yeah,
And you saw the police with their sirens in a marked uniform and marked vehicle?
yeah,
And you knew that you were supposed to stop because they were acting in their official capacity, and you failed to stop, is that correct?
yeah.
Did you take off or go in a different direction than they told you to?
Well, I never took off, so I just not stopped right away.
You just didn't stop?
Right away, yeah.
Okay, did you eventually stop?
Yeah,
Okay, but you should have stopped a lot sooner,
yeah,
and you were continuing to go forward without stopping, trying to elude them?
nah,
Counsel?
I would say, did you, like you said, Mr. Perez, you were in an area where, like in a residential area, like, you were going home, right?
yeah,
And the street was less than 30, the miles per hour, the speed limit was less than 35 miles an hour, right? And you were being directed to stop your vehicle, correct?
mhm,
And
Is that a yes?
yes,
and you did not stop it, correct?
yeah,
Now, you didn't necessarily speed up, correct? But you did not slow down or stop.
yeah,
You continued until you got home, right?
yeah,
All right, and so do you agree that you were disobeying, you were attempting to flee?
okay, yeah,
Your Honor, I believe that's all I can get.
On behalf of the people,
The people are satisfied, Your Honor.
our counsel will promise to stress our inducements other than those already placed on the record.
No, Your Honor.
No,
As court complied with court rule.
You have, Your Honor.
yes.
Sir, how far did you drive once you saw, or maybe you can answer that, counsel, is it in the police report?
It is in the police report, Your Honor.
I mean, was it just a few blocks to his house, or was
Yeah.
it longer?
It was, the traffic stop started on, while they were traveling west on Saginaw Highway. His street I would say it'd be about 6 or 7 blocks,
No, less than.
or less than that, before he turned onto his street and then pulled it and then continued to his driveway.
Okay. I find defendant's plea has been freely, voluntarily, knowingly and understandingly made without undue influence, threats, coercion, or promises of leniency. Has the court complied with the court rule?
You have, Your Honor.
Yes.
And I also find there are sufficient grounds to accept defendant's plea given the full circumstances. Therefore, count 1 will enter count 2, and the habitual 4th are dismissed in their entirety. Any outstanding warrants, if any, related to this file are also recalled and dismissed. Do you have a sentencing date?
June 17th at 10:30.
Does that meet with your schedule?
That's fine, Your Honor, thank you.
All right, sir, you need to make and keep an appointment with probation. You should probably go down now. Otherwise, you can call them. The number is 483-6100. It's on the purple sheet, but we can't go to sentencing without that pre-sentence investigation report. So please go downstairs and make and keep that appointment. Bond and bond conditions are continued. Anything else we need?
No, Your Honor.
No, thank you.
All right, thank you. That's all.
Yep.
We're gonna do Mohammed Perkins next.
Yes. This is docket 25-5598 FH, People of the State of Michigan versus Mohammed Idris Perkins. Counsel, your appearance for the record.
Good morning, Your Honor. EPA Bart Buxton on behalf of the people of the state of Michigan.
Your Honor, Fred Blackman on behalf of Mr. Perkins, may I approach?
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
All right, thank you. And put your hand up. Have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, Your Honor.
Have you had enough time to speak with Mr. Blackman?
Yes.
I understand there's going to be a plea today, is that correct?
Yes, ma'am.
And do you still live on Chestnut?
No, ma'am.
All right, do we have your new address? Is it on the advice rights form?
Yes, I put April, I think it's April.
Oh,
Is that correct?
April?
Yeah,
Okay, we
April.
have that, okay. I have that on different forms, so you must have provided it before. Okay, and were you on probation, parole, or bond conditions at the time of this offense?
Yes.
And that was probation with me?
Yes.
Anybody else?
No.
Will this result in a probation violation, or they
It
take
is,
care of
and
that?
part of the resolution is on the probation violation, we run both sentences concurrent and not to exceed the other.
Okay. All right, and you're a US citizen?
Yes, ma'am.
What is the plea agreement for the record?
Yes, Your Honor, the plea agreement is that the defendant will be pleading to count 3, possession of a controlled substance, specifically cocaine, less than 25 grams, and count 4, maintaining a drug house. Upon successful plea and sentencing, counts 1, 2, 5, 6, and 7, as well as the again, yes, I'm sorry, he will be pleading the habitual 4th as well. It is written in counts 3 and count 4.
Oh, I see at the top, so he's
Yes.
gonna plead to the official.
Yes, he will be pleading the 4th. I apologize, I'm
Okay,
doing this for another attorney. There were a sentencing agreement to a minimum sentence would be fixed at 20 months. MDOC max is 15 and to run concurrent with any PV sentence. The defendant also agrees for forfeiture of all seized narcotics and weapons, even in dismissed counts.
full, fair, accurate, and complete,
It is, yeah.
full, fair, accurate, and complete,
Yes, ma'am.
all right, and counsel, you're waiving reading counts 1, 2, 5, 6, and 7,
I am.
as to the reading of 3, 4, and habitual 4 in its entirety, thank you.
Yes, Your Honor. People of the State of Michigan versus Mohammed Idris Perkins, State of Michigan, County of Hingham, in the name of the people of the State of Michigan. The prosecuting attorney for this county appears before the court and informs the court that on the date and the location described below, the defendant in count 3, controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams, on or about August 21st, 2025, at 2700 Eaton Rapids Road, Lot 200, Lansing, Michigan, 48911, Ingham County, State of Michigan. The defendant did knowingly or intentionally possess less than 25 grams of a mixture containing a controlled substance, cocaine, contrary to statute. This is a felony that is punishable up to a maximum of 4 years. However, with the habitual offender, that would be a 15-year offense. Count 4, controlled substance maintaining a drug house, on or about August 21st, 2025, at 2700 Eaton Rapids Road, Lot 200, Lansing, Michigan, 48911, Ingham County, in the State of Michigan. The defendant did knowingly or intentionally keep or maintain a dwelling that was used for the keeping or selling of controlled substances in violation of Article 7 of the Public Health Code, being MCL 333.7101, as well, contrary to statute. This is a high court misdemeanor that is typically punishable up to a maximum of 2 years and or $25,000. However, with the habitual 4th offender status, it would be a maximum of 15 years. The habitual offender 4th notice, take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, in that on or about December 21st, 2016, he or she was convicted of the offense of controlled substance, possession less than 25 grams, in violation of MCL 333.7403285 in the 30th Circuit Court for Ingham County in the State of Michigan. And on or about June 7th or July 7th, 2021, he or she was convicted of the offense of controlled substance, possession less than 25 grams, in violation of MCL 333.7403285 in the 30th Circuit Court for Ingham County in the State of Michigan. And on or about October 8th, 2024, he or she was convicted of the offense of carrying a concealed weapon in violation of MCL 750.227 in the 30th Circuit Court for Ingham County in the State of Michigan. Therefore, the defendant is subject to penalties provided by MCL 769.12. Those penalties being life if primary offense was a penalty of 5 or more years, or 15 years or less if primary offense has a penalty of under 5 years. The maximum penalty cannot be less than the maximum term for the first conviction. Court shall order law enforcement to collect DNA identification profile sample before sentencing or disposition, if not taken at the time of arrest, and against the peace and dignity of the state of Michigan.
Thank you. Make sure all phones are turned off. Sir, did you understand what was just read?
Yes, Your Honor.
So you understand count one, weapons, firearms, possession by a prohibited person, normally a 5-year, I'm sorry. I forgot to cross that out. It's count three. Not count one. Count three, possession of a controlled substance known as cocaine, less than 25 grams, normally a 4-year felony. Because of the habitual fourth, there is the enhancement to 15 years. You understand that?
Yes, Your Honor.
And you understand count four, maintaining a drug house, controlled substances, normally a high court misdemeanor of 2 years, now is a 15-year.
Yes, ma'am.
And let me just ask the status of the 23358 FH file. He's not completed probation, correct?
In the 23 case. What was the latest case, the CCW? The CCW. No, he's just on probation on the CCW.
Yeah, he was sentenced October 7th, 2024. You're still on probation for that.
Yes, Your Honor.
So I just want to be clear, the intention is that this will be revoked or closed and whatever time is on.
Right, yes.
All right, so I'm going to set this the same time as sentencing.
That's great. Judge.
Okay, great.
And I'll enter my appearance on that. Just make sure.
Okay, I have you.
Do you?
Oh, no, I don't. You know what? I wrote a note on this, that this file should travel with this file that you were on. So,
I'll make sure it's done.
yeah, do an appearance. Okay. So, sir, looks like you signed the advice of rights form. Did you read it before you signed it?
Yes,
Did
ma'am.
you understand what you read?
Yes, Your Honor.
And if you had any questions about your rights, you're able to talk about those with Mr. Blackman?
Yes.
Do you have any questions about your rights at this court?
No, ma'am.
And sir, you understand you're giving up your automatic right of appeal. If you choose to appeal, you first have to ask permission of the Court of Appeals. If you have a bench trial or jury trial, you have an automatic right of appeal, but now it becomes their decision if you choose to appeal. Do you understand?
Yes, ma'am.
All right. Sir, as to count three, possession of a controlled substance known as cocaine, less than 25 grams, how do you plead?
Guilty.
As to count four, maintaining a drug house, controlled substances, how do you plead?
Guilty.
And sir, you understand that you are giving up your presumption of innocence, your right to a trial, your right to cross-examine witnesses and evidence, your right to choose to bring evidence in your defense and request witnesses that the court would provide, the right to remain silent, not have it used against you. You understand you're giving up all of that.
Yes, Your Honor.
All right. And you chose to plead after you spoke with your attorney,
Yes, ma'am.
and your plea to both counts has been freely made of your own free will,
Yes.
and you've been satisfied with the representation of your attorney.
Yes, ma'am.
And there is this recommendation as to sentencing for 20 months in the Michigan Department of Corrections that will run concurrent with your other file. If I violate that, I would allow you to withdraw the plea, and this matter would again go to the pretrial stage. However, if you violate the law between now and then, I don't have to honor that. I'm not locked into that. I don't have to allow you to withdraw your plea. Do you understand that?
Yes, ma'am.
All right, very good. Sir, did these events occur on or about August 21st, 2025,
Yes.
in the township of Delhi County, Bingham State of Michigan,
Yes, ma'am.
at a specific location known as 2700 Eaton Rapids Road, Lot 200?
Yes, Your Honor.
Did you have in your possession at that location 20 mixture containing less than 25 grams of cocaine?
Yes, ma'am.
And how is it you came in contact with law enforcement? How did they come to find it? Was there a search?
There was a
Search.
search, there was a search of the record.
Search, Your Honor.
And was there a search warrant?
Yes, it was legal.
And so if there's any defect in that warrant, it's being waived.
Right.
All right, I take it from what you said, you waived that issue.
Yeah, okay.
And you didn't have any license or special permission or authority to have that cocaine, is that correct?
Yes, ma'am.
And when law enforcement found it, do you know where they found it?
In the bedroom, Your Honor?
It was your bedroom,
Yes,
it was
ma'am.
under your control,
Yes, Your
and
Honor.
you placed it there?
Yes, ma'am.
And did a drug test confirm that it was in
It
fact
did
cocaine?
confirm it was 3.215 grams of cocaine.
And sir, were you also allowing other people to use drugs in your home?
Yes, Your Honor.
And were you also providing some drugs to them or sharing it with them?
Share.
I don't know if you, were you
You were
sharing drugs with them?
delivering, you were sharing.
Sure, yes, ma'am.
Okay. And you didn't have any license or special permission or authority to do that either, did you?
No, ma'am.
All right, and this was done at your home, that's where you lived?
Yes, Your Honor.
All right, on behalf, oh, no, and then we've got the visual force, so you were convicted on or about December 21st, 2016, of the offense of controlled substance possession less than 25 grams in violation of the statute in 30 Circuit Court for Union County, is that correct, sir?
Yes, ma'am.
And then on or about July 7th, 2021, you were convicted of the offense of controlled substance possession less than 25 grams in violation of the statute in 30 Circuit Court. You agree with that as well?
Yes, ma'am.
And then on or about October 8th, 2024, you were convicted of the offense of carrying a concealed weapon in violation of the statute in the 30th Circuit Court. You agree with that as well, sir?
Yes, Your Honor.
So you understand that's where the habitual fourth comes. This is now habitual fourth, which is why you have that enhancement from the 4 years to the 15 years and the 2 years to the 15 years. You understand that?
Yes, ma'am.
All right. On behalf of the people, any additional questions?
People are satisfied, Your Honor.
On behalf of your client, any additional questions?
Likewise, I'm satisfied, Judge.
Our counsel where promises, threats, or inducements other than those already placed on the record.
No, Your Honor.
None, Your Honor.
Score by the court will.
You have, Your
You
Honor.
have it.
Thank you. I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there sufficient grounds to accept defendant's plea. Therefore, counts 3 and 4 will enter. Counts 1 and 2, 5, 6, and 7 are hereby dismissed along with the habitual fourth in its entirety. Any outstanding warrants, if any related to this file, are also recalled and dismissed. And all controlled substances, paraphernalia, weapons, ammunition, any contraband is hereby forfeited.
Your Honor,
Yes.
isn't it the habitual offense we're going on?
Oh, I'm sorry. You're right. I dismissed the habitual because I originally wrote that. The habitual offense is not dismissed.
Yes,
Nice
thank you.
catch. Okay. So 3 and 4 goes with the habitual fourth. 3 and 4 will go up with the habitual fourth. It is 1, 2, 5, 6, and 7 that's dismissed. Originally, when I didn't see it on, I had that still stuck in my head. Yeah. All right. And your sentencing date.
June 17th at 11 a.m.
Judge, I'm May and June, most of, I do conflict counsel down in Jackson. I got a ton of jury trials with the court considered first part of July for sentencing.
Well, there you have it. I'm generally like in the sun and however, I do have, I think,
June 24th is the next day I have.
okay,
the
June
full-
24th.
May and June, I'm down in.
Oh, yeah, okay, so, well, let me ask you this, counsel, can we do it on Zoom?
We could, Judge, but you know, he's got time in, I mean, he's gonna be sitting there and it's a 26th,
Yeah,
so it really doesn't.
well, so, and this is not dead time, so he's getting.
No, it's not dead time
All right,
at all.
let's just do it in August.
I don't
We're not
have
in any hurry to get to prison, are you? All right, let's do August.
I don't have questions on the call.
Okay. I guess we'll be hosting you for a while. All right, I need a date in August for a sentencing. Let's do the 19th. What time? 9:30, thanks. All right, August 19th at 9:30.
Thank you, Judge.
Sir, you'll have to cooperate with probation, but they're going to come and see you. And they're gonna do a detailed pre-sentence investigation report. They'll probably just update the one that you have in your file. But what I'm going to do is set both of these files for that day. And then I have to see what you completed on the 23-358 FH file. If you've done enough, I'll simply give you credit for that. Otherwise, I'll send it to you on both. Does that make sense to you?
Yes, ma'am.
Okay. So, and Mr. Blackman, you're gonna file an appearance
I will do that, Judge.
and we'll take a look at that. Maybe you want to talk to the agent. We'll.
I think we are, Randy Bierman, who was on this already.
Okay, thank you. And that's all for the record.
Thank you,
If need
Judge.
Something over in the jail or not helping you out, let your attorney or me know, okay?
All right, thank you.
Rachel, before we're doing this one.
Oh, okay, I didn't know. No, okay.
We're doing Melvin Chapman next. You were gone. You were gone. We had the circle. I did, but then the court already has the file. I'm just putting you on control. Yes.
He is on Zoom, Your Honor. He's in the Department of Corrections.
Okay. What is he?
Should be
The ARF
hearings two.
Oh, okay, gotcha. All right, this is docket 25-1148 FH, People of the State of Michigan versus Melvin Chapman. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
And thank you, Your Honor. Good morning. Jared Austin appearing on behalf of Mr. Chapman. He appears with us remotely from the Department of Corrections.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
And have you had enough time to speak with your attorney?
Yes, ma'am.
All right, thank you. And I understand you're in the Department of Corrections.
Yes, ma'am.
Or your out date,
His earliest release date is July of 27.
July 27. All right, earliest. All right, thank you. And I take it we have a plea agreement, is that correct?
That is correct, Your Honor.
What is that?
And the plea will be to count 2, delivery and manufacturing of a controlled substance known as cocaine, less than 50 grams. Upon successful plea and sentencing, count one will be dismissed and the habitual offender will be amended to a third offense notice instead of a fourth offense notice. There is also a Killebrew agreement to a fixed minimum of 19 months at the MDOC. And there is also a agreement that this sentence will run concurrent with his current sentence at MDOC, which I believe is 23-357-FH, which is here, which is from this county. And there will also be forfeiture of all contraband seized.
Full, fair, accurate, and complete, counsel?
It is, Your Honor, and that's what I have conveyed to Mr. Chapman, and I believe that is what is accurately reflected on the plea agreement form that has been signed by both counsel.
Sir, is that full, fair, accurate, and complete? Mr. Chapman, did you hear the agreement? Is it complete?
Yes, ma'am.
Okay, and counsel, you're waiving reading count one and the habitual fourth, the habitual third one, correct?
Yes, we will wait.
All right. As to count two and the habitual third.
Yes, Your Honor, people of the state of Michigan versus Melvin Chapman, state of Michigan, county of Ingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and the location described below, the defendant in count two, controlled substance, delivery/manufacture of a controlled substance, cocaine, less than 50 grams, on or about February 6, 2025, at Walnut Street/Lapeer Street, Lansing, Michigan, 48933, Ingham County, in the state of Michigan. The defendant did possess with intent to deliver less than 50 grams of a mixture containing a controlled substance, cocaine, contrary to statute. This is a felony that is punishable by up to a maximum of 20 years and or $25,000. A consecutive sentence may be imposed for any other felony conviction. Habitual offender, third offense. Take notice that the defendant was previously convicted of 2 or more felonies or attempts to commit felonies. In that on or about September 25th, 2024, he or she was convicted of the offense of possession less than 25 grams of cocaine, heroin, or another narcotic in violation of MCL 333.7403 2A5 in the 30th Circuit Court for Ingham County in the state of Michigan. And on or about May 18, 2016, he or she was convicted of the offense of controlled substance delivery and manufacturing cocaine, heroin, or another narcotic less than 25 grams in violation of MCL 333.7401 2A4 in the 30th Circuit Court for Ingham County in the state of Michigan. Penalty is, I apologize, Your Honor, it would be double, but let me get the exact wording. Penalty is twice the maximum sentence on a primary offense or lesser term. Maximum penalty cannot be less than the maximum term to the first conviction. That would mean that count 2 would, instead of a 20-year max, be a 40-year max. Court shall order law enforcement to collect DNA identification profile sample before sentencing or disposition without taking the time of arrest and against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read?
Yes, ma'am.
So you understand count 2, delivering, manufacture, and controlled substance known as cocaine, less than 50 grams, is a felony, normally 20 years, but because of the habitual third, it doubles it to 40. You understand that?
Yes, ma'am.
And sir, did you go over your rights with your attorney?
Yes, ma'am.
Would you like me to read them into the record and remind you of them, or are you satisfied so your attorney can sign the form on your behalf?
I'm satisfied with the form.
And I would just note, Your Honor, obviously I'm not able to have him formally execute an advice of rights due to him appearing remotely. However, I did orally review and go over each and every one of those rights contained on the advisor rights form.
Thank you. He acknowledged that, and I know that's your usual practice, so thank you. All right, sir. And just so we're clear, sir, you understand that now by pleading, you are going to lose your automatic right of appeal that you would have had you decided to go to trial. So it becomes the decision of the Court of Appeals. If you're unhappy about anything, if they think your issues are important, they'll take up your case, but they don't have to. Do you understand that?
Yes, ma'am.
You're also giving up your presumption of innocence, the ability to cross-examine witnesses and evidence brought against you, the ability to choose to provide a defense and provide evidence and witnesses that the court would order to be present, and to use your ability to remain silent without it being used against you in any way. You're giving up all of those rights. You understand?
Yes, ma'am.
Sir, as to count 2, delivery, manufacture, of a controlled substance known as cocaine less than 50 grams, how do you plead?
Plead guilty, ma'am.
And sir, do you understand that as far as the plea agreement, if I do not follow the recommendation of, it's the agreement between all of you, it's only a recommendation to me, of the 19 months to 480 months and running at concurrent with the sentence you're now serving. If I don't follow that, I would allow you to withdraw your plea and this matter would again go to the pretrial stage. Do you understand that?
Yes, ma'am.
However, if you violate the law between now and sentencing, I don't have to honor that, and I don't have to allow you to withdraw the plea. Do you understand that?
Yes, ma'am.
All right. Sir, did this offense occur on or about February 6, 2025?
Yes, ma'am.
In the city of Lansing County, being the state of Michigan,
Yes, ma'am.
at a specific location known as Walnut Street and Lapeer Street in Lansing?
Yes, ma'am.
You came in contact with law enforcement
Yes, ma'am.
and they discovered that you were in possession of a quantity of cocaine less than 50 grams. Is that correct?
Yes, ma'am.
And you had that amount with the intent to deliver, is that correct?
Yes, ma'am.
And how was it you came in contact with law enforcement?
While I was in the back seat, a friend was driving and got pulled over.
I was in the back seat and I was what?
A friend was driving and he got pulled over. And to further supplement that, Your Honor, Mr. Chapman was one of multiple occupants in a vehicle. It was initially pulled over because the vehicle was driving at night without lights on. There was some further investigation done in conjunction with that stop. I think Mr. Chapman, it was discovered at that time that he had maybe an active warrant, so he was taken into custody on that, and then it was discovered that he had controlled substance on his person.
So this was a search incident to arrest, doesn't sound like there's a defect in that, but if there is that being waived?
That would be correct, Your Honor, although my review of it from the report and from the testimony at the preliminary hearing is that there would not be any constitutional issues or violation with that stop. Had there been, I would have filed a necessary motion to challenge that.
But you know, I always ask.
No, understood, and I just wanted to make a record of
I
that.
appreciate that, okay. And sir, you didn't have any license or special permission or authority to have that cocaine in your presence, under your control, or to sell it or distribute it, correct?
Yes, ma'am.
All right, and you would agree that it was an amount less than 50 grams?
Yes, ma'am.
And sir, you were previously convicted of 2 or more felonies in that on or about September 25th, 2024, you were convicted of the offense of possession less than 25 grams of a controlled substance in violation of the statute in the 30th Circuit Court for Ingham County.
Yes, ma'am.
And you were also convicted on May 18th, 2016 of the offense of controlled substance delivery manufacture of controlled substance less than 50 grams in the 30th Circuit Court, correct?
Yes, ma'am.
So this would then be your third offense, meaning that that's why you have that enhancement from 20 years to 40 years. You understand all of that?
Yes, ma'am.
On behalf of the people, anything further?
People are satisfied, Your
On
Honor.
behalf of your client
I'm satisfied, Your Honor, thank you.
or counsel where promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
I'm aware of none.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, trust, coercion, or promises of leniency. Also find there are sufficient grounds to accept defendant's plea, therefore count two will enter with the habitual third offense notice. The habitual fourth is dismissed along with count one. Any outstanding warrants, if any, are recalled and dismissed. And all contraband, weapons, drugs, paraphernalia, etc. is hereby forfeited. Do we have a sentencing date?
June 17th at 11 a.m.
Does that meet with your schedule, counsel?
It does, Your Honor.
All right, sir, you'll cooperate with probation. They will do a pre-sentence investigation report. We'll all talk about that at the time of sentencing. Do you have any questions?
No, ma'am.
All right, good luck to you, sir. That's all for the record.
We're going to do Michael Barnes next. It's the first one at 9:30. Kevin was number 3.
Oh, there I see it. Okay.
Hey, Ahmad. Hello.
We're on Barnes. You're not up whoever's screening.
It's Mr. Carr. I think he was removed from the breakout room. We put him back in there.
He removed himself, I didn't do it.
Can we still put him back in there?
Okay.
Thank you.
Okay, where's your client? Is he on Zoom?
No, Your Honor, he's not here.
Oh, okay. This is docket 25-1145 FH, People of the State of Michigan versus Michael Wayne Barnes Jr. Counsel, your appearance for the record.
Good morning, Your Honor. EP Barbucks on behalf of people of the state of Michigan.
Good morning, Your Honor. Attorney Derek Etheridge from Rosemarie Public Defender on behalf of Mr. Barnes, who is not present today.
Have you heard from him recently?
Your Honor, I've had good contact with him in the past. I did talk to him about this court date. He was aware of it. I did make a referral to the social worker in the past regarding some issues he was having. I saw those notes in there. I did attempt to call yesterday and today to talk to him about the case, but was not able to get in contact with him. As far as I'm aware, he hadn't missed any court dates, and he's usually early when it comes to court dates. But I'm not sure why he's not here today, Your Honor.
All right, well, bench warrant bond forfeiture will enter today at 3 p.m. So if he wants to show up before then, we'll lift it. Otherwise, get him here and we'll figure it out.
Thank you, Your Honor.
Yes.
Oh, then great.
Very well.
Thank you.
We're going to do Andrico Brooks.
The paperwork.
Just sign it.
Yeah, Lisa.
He's not gonna.
Correct. Gotcha.
Is this going to be a plea?
Not anymore, Your Honor.
Oh, okay. Have we had a final pretrial?
I believe we have, Your Honor.
Have we had a final pretrial?
My understanding and my memory is that we have, and that, as a matter of fact, the people even amended their offer with respect to a sex-related offense, and that was conveyed to my client on what I thought was our final pretrial.
So today we'll discuss the guidelines, the offer, the rejection, and then trial date.
Okay, because I do have December 10th, there was a plea offer. And
Maybe we should go on the record first.
yeah, I'm just trying to figure out, because I don't have notes on the final pretrial, so I just want to figure out what we're here for.
It was filed pre-trial before, it was handled off record once we established that there was gonna be a plea, but more time was needed, so then there was a plea date established for today.
Okay, so let's go on the record then.
Yeah.
This is docket 25-1892 FC, People of the State of Michigan versus Enrico Ramon Brooks. Counsel, your appearance for the record.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Stephen A. Freeman, Public Defender, on behalf of Mr. Brooks, who is standing to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes,
Will you put your hand down? Sir, have you taken any medication yesterday or today?
today,
Is there anything that would interfere in your ability to understand the attorney or this court?
No.
Is there medication you're supposed to be on that you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
Have you spoken to your attorney?
yes,
And sir, I understand that this was supposed to be a plea hearing, but you decided not to plead, which is fine, it's your right to go to trial, but then this is going to turn into a final pretrial date. So that people are going to make their final offer and you have to make a decision what you're doing, and it sounds like you've already made that decision to go to trial, am I correct?
yes, ma'am.
Okay, so no objection to waiving any notice, if any, is required in regard to the final pretrial?
No objection, Your Honor. Thank you.
None, Your Honor.
Thank you. What is the offer?
Your Honor, the defendant is charged with 18 counts, 16 of which are felonies, several of which are light offense felonies, including torture and criminal sexual conduct in the first degree. As charged, due to the number of discretionary and mandatory consecutive charges he has, his guideline range at a trial is between 159 and 670 months. To make it more plain, it's between 13 and 56 years as a minimum sentence at trial. The offer was for the defendant to plead guilty to count 6, domestic violence second offense, count 7, home invasion first degree, count 10, felony firearm, count 12, aggravated stalking, and then an added count 19, criminal sexual conduct in the fourth degree, incapacitated person. The original offer was for a third degree. What was expressed to me was that the defendant did not want to be on the public registry. I discussed it with my front office and the victim, and they both agreed to make a counter offer for CSC fourth because he would not be on a public registry there. When we were last here, Mr. Freeman discussed it with his client, was told that he wanted to take the deal and just need more time because of the sheer number of charges to make sure they can make a good factual basis. And it appears that the defendant does not want to take that. The offer included a sentencing agreement to fixed minimum of 120 months, including the 24 months from the felony firearm. The minimum guideline range for that offer was between 108 and 180 months, between 9 and 15 years, and the offer was for 10 years.
We'll say 108 to what?
180.
Okay,
So between 9 and 15 years just on the offer, and the agreement was for 10 years. It's my understanding the defendant does not want to accept that offer, but to make sure there's a clear record for the appellate courts, I think we need to hear from him on the record that he understands it. That's not one.
Well, that's the usual practice, we'll do that, but I want to understand, just make a further record, so I think it's clear, but who knows? The 120 months would include the 2 years, so it'd actually be 2 years plus 8 years.
Effectively, yes. The,
Okay,
the goal is for all the charges he plead guilty to, it would be 10 years.
okay. So, is that full, fair, accurate, and complete, counsel?
That is exactly that, Your Honor, yes.
Full, fair, accurate, and complete, sir?
Yes,
And it's your intention to not accept the offer?
correct.
Did anyone force, threaten, or coerce you into this?
No.
Anyone promise you anything that caused you to reject the offer?
No.
You made this decision of your own free will?
No.
And you did that after you've consulted with counsel?
Correct.
And you've been satisfied with counsel?
Yeah,
And sir, you understand that the guideline difference here, if you're convicted, is significant, 13 years to 56 years. But your agreement would be for a set 10 years. So you could serve 56 years if you're found guilty.
She's not saying you will.
I'm not saying you will, but I'm just giving you the difference between the two. At worst, 56, I could go over that. The guidelines are only recommended. I don't know what I'll hear. I could go under. I don't know what I'm gonna hear, but you do have 18 very serious counts. And you're in, there are two that are life offenses. You understand, and you wish to toss the deal and go to trial.
yes, ma'am.
All right, that's your right. I can't sway you either way, even if I could. I don't have any information to do that. So, you know, it's all between all of you, so it's fine with me. I don't even get police reports, so happy to take this to trial. And we have a trial date.
We had a scheduled trial date of April 24th. The people are going to need an adjournment due to a discovery issue with the defendant's phone that the police are still going through. In the lead up to the final pre-trial conference, I emailed the, I think I called the detective to make sure we had everything. She informed me they're still going through the phone because there's a backlog over there for their computer forensics division. And was going to be bringing that up at the final pre-trial, but then I was told that there was going to be a plea. So I think they stopped going through it. So I'm going to be contacting them today to say they need to recontinue that process.
Okay, what's the new trial date?
I'm not sure. We're trying to see.
Time in June?
And I'll get some more down there. So, May 22nd, it looks like I already have some here that works for defense counsel schedule. And then I'm gonna follow up with them. The detective wasn't able to give me a time frame simply because she's not in the computer forensics division. It varies case to case. But if there is more time needed, I will let the court know before that date. I'm gonna try and keep getting updates to get a good headspace on where they're at.
All right, well, tell them the trial date's up and I know how to move it.
I will.
Your Honor, if I may, as an officer of the court and in the interest of full disclosure, I'm concerned that the plaintiff's counsel perhaps wasn't aware of this. I too would join in the motion for an adjournment from the April date. I'm scheduled for a procedure on April 22nd that I don't think you were aware of. And
Will you be recovered by May 22nd?
by May 22nd, yes, I'm anticipated to be a week to 10 days out of the office.
All right, well, I hope everything goes well.
Thank you.
And May 22nd, you'll be ready to go.
Yes, thank you.
And then you'll deal with the clothing and all those other issues.
Of course.
And if there's any preliminary matters we need to address, even if I have to do it on lunch hour, let's get it done.
Absolutely, Your Honor.
And you'll work together on jury instructions.
Understood.
Absolutely. And
Thank you.
we will, May 22nd, please.
Is this gonna be a week or two weeks? It looks maybe
2
like 2 weeks with all these counts.
Most likely. Which is why I'm looking into May 29th, the following week, where there's an open murder.
I don't see it going to a jury in a week. I think it's gonna bleed over myself.
Let's leave it for May 22nd. We'll discuss it. If there, I think there's serious concern, it's gonna go through to the next week. I'll let the court know and see if we need to try and get a different one, simply because for that next week, I see first up as an open murder.
Depends how long that would take. I mean, if you're only gonna take, let's say, a week and a half, we could start jury selection on Tuesday while the other case is
It looks
deliberating.
like.
But your
AP
office can get their act together in terms of all of you and figure out your timeline and then let me
Exactly.
know. All right, great. Right now it's May 22nd. Today we have used it as the final pretrial, so now it's time to get ready for trial with your attorney, okay, sir? You're getting what you need at the jail? Are you getting what you need at the jail?
Yeah.
All right, thank you. That's all for the record.
Thank you, Your Honor.
Frederick Cole next.
Is docket 25-5187 FH, people of the state of Michigan versus Frederick Cole. Counsel, your appearance is familiar.
Good morning, Your Honor. AP Verbucks on behalf of the people of the state of Michigan.
Fred Blackman on behalf of Mr. Cole. He's standing to my right at podium, and may I approach him?
You may. I have this already. Slide.
Do you? You might, because we might have, I think it's the exact same thing.
It's the exact same thing. Yep. All right.
Yeah.
I have,
I think we were here before, Judge, and we
Yeah,
couldn't take
I'm
a
gonna
plea.
just
Didn't have the time to do the plea that day. This is docket 25-5187 FH, people of the state of Michigan versus Frederick LaShawn Cole. Counsel, your appearances. Good morning, Your Honor. AP Verbucks on behalf of the people of the state of Michigan.
Fred Blackman on behalf of Mr. Cole. He's standing to my right.
Sir, you've been very patient this morning. Thank you. Please raise your right hand. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and come to perjury?
Yes, ma'am.
Thank you. Raise your hand here. Sir, you are a U.S. citizen,
Yes, ma'am.
and you had enough time to speak with your attorney.
Yes, ma'am.
Are you employed?
Yes, ma'am.
And what do you do?
I work in General Motors in the paint shop.
Okay, good. And I understand there's going to be a plea today. Were you on probation or parole or bond conditions before another judge at the time of this offense?
I don't believe he was on bond. He had another case real simultaneously with this. Judge Cunningham knew all about it.
Okay,
And he was just sentenced to probation. We did an
that was taken care
pardon
of.
me?
It's all taken care of.
Yeah, he's on probation right now.
Okay, I just have to ask sir to make sure that you're fully advised of any other repercussions, but sounds like you handled all that, so that's good. All right, and what is the plea agreement?
Yes, Your Honor, the defendant will plead to count 1, assault with a dangerous weapon, otherwise known as felonious assault, and count 3, possession of a loaded firearm in or upon a vehicle. Upon successful plea and sentencing, count 2 would be dismissed. There is also a kill-or-brew agreement, Your Honor, to no upfront jail at the time of sentence.
Full, fair, accurate, and complete?
It is, Your Honor.
And additionally, Your Honor, I apologize, there's also forfeiture of any contraband seized as a result of this incident.
Yeah, that's okay, this is a part of the statute, so we're good. All right, full, fair, accurate, and complete?
Yes.
Full, fair, accurate, and complete?
Yes, sir.
All right, counsel, you're waiving reading count 2.
I do.
As to count 1 and 3.
Yes, Your Honor, people of the state of Michigan versus Frederick LaShawn Cole. State of Michigan, County of Ingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant in count 1, assault with a dangerous weapon or felonious assault, on or about June 30th, 2025, at 5212 South Waverly Road, Lansing, Michigan, 48911, Ingham County, State of Michigan, the defendant did make an assault upon Brayton Jennings with a dangerous weapon, to wit, a rifle, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, contrary to statute. This is a felony that is punishable up to a maximum of 4 years and/or $2,000. DNA to be taken upon arrest. Consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. In count 3, weapons, firearms, possessions of a loaded firearm in or upon a vehicle. On or about June 30th, 2025, at 5212 South Waverly, Lansing, Michigan, 48911, Ingham County, State of Michigan, the defendant did possess and transport in or upon a motor vehicle a loaded firearm, which was not a pistol, to wit, a rifle, contrary to statute. This is a misdemeanor that is punishable by up to this is a high court misdemeanor that is punishable by up to a maximum of 2 years and/or $2,500 with mandatory forfeiture of the weapon or device seized. The court shall order law enforcement to collect DNA identification profile samples for sentencing or disposition, if not taken at the time of arrest, and against the peace and dignity of the state of Michigan.
Thank you. Sir, did you understand what was just read?
Yes, sir.
So you understand count 1, assault with a dangerous weapon, also known as felonious assault, is a felony punishable by 4 years. And count 3, possession of a loaded firearm in or upon a vehicle is a high court misdemeanor punishable by 2 years.
Yes, sir.
And it looks like you signed the advice of rights form. Did you read it before you signed it?
Yes,
Did
sir.
you understand what you read?
Yes, sir.
And if you had any questions, you were able to ask those of your attorney?
Could you repeat?
If you had any questions in regard to your rights, you were able to ask those of
Oh,
your
yes, sir.
attorney? Do you have any questions about your rights of this court?
No, no.
Sir, as to count 1, assault with a dangerous weapon, also known as felonious assault, how do you plead?
Guilty.
As to count 3, weapons, firearms, possession of a loaded firearm in or upon a vehicle, how do you plead?
Guilty.
Do you understand that by pleading, you're giving up your automatic right of appeal? If you choose to appeal, you first have to ask permission of the Court of Appeals to appeal. Had you had a bench or jury trial, they must take a look at your unhappiness if you appeal, but now it becomes their choice. Do you understand that?
Yes, sir.
And you're also giving up the presumption of innocence, the ability to cross-examine witnesses and evidence, the ability to choose to provide defense and request witnesses be ordered by the court to appear. And if you so chose, the ability to have your silence not be used against you. You understand you're giving up all of those things.
Yes, sir.
And you chose to plead after you looked at everything and talked about everything with your attorney, Mr. Blackman.
Yes, sir.
You've pled of your own free will to both counts.
Yes, Your Honor.
And you've been satisfied with the representation of your attorney?
Yes, Your Honor.
Now, has anyone told you what I will do at sentencing?
No, Your Honor.
And that's because I don't know, but I'm fully informed and I'll make up my mind. Do you understand that?
Yes, Your Honor.
All right, and there's a recommendation for no upfront jail. If I violate that, I would allow you to withdraw the plea and this matter would again go to the pre-trial stage. However, if you violate the law or bond conditions, I don't have to honor that. I don't have to allow you to withdraw your plea. Do you understand that as well?
Yes, Your Honor.
Sir, did these offenses occur on or about June 30th, 2025
Yes, Your Honor.
in the county of Bingham, state of Michigan,
Yes, Your Honor.
at a specific location known as 5212 South Waverly Road?
Yes, Your Honor.
Did you come in contact with Brayton, Brayton Jennings with a dangerous weapon?
Yes, Your Honor.
Was that weapon a rifle?
Yes, Your Honor.
And would you agree with me that a rifle is a dangerous weapon?
Yes, Your Honor.
And did you intend to assault him but not inflict great bodily harm, such as murder?
May I ask?
Yeah.
Okay, on the state and time question, you were at where this person was earlier, is that correct?
Correct.
Selling fireworks, is that correct?
Correct.
Got in a big argument with that particular individual, is that correct?
Correct.
And then did you come back a little bit later?
Yeah, the person's firearm, I did.
Yeah, and so then you had a.
Not firearm, fireworks, I'm sorry.
Yeah, fireworks, okay, but you had, in your vehicle, you had a long rifle, is that correct?
Correct.
When you came back, you made sure you showed him that because you were upset and you believe by doing that, he was scared. He got scared because he saw that rifle with you.
Correct.
And you didn't intend to murder him?
You didn't intend to murder him?
Just to, okay. And sir, you actually had that rifle that you got out of your vehicle, and you had transported it loaded, is that correct?
Yes, I went back home. I lived down the street. So when I went back home and parked in my driveway, I just went in the house, chill out, and I left it in my trunk.
Okay, but you did drive with.
Yes, ma'am. Yes, sir.
Okay, and, is there gonna be any, this will sound like, is there gonna be any restitution that's due to it?
I don't believe so, Your Honor. There's not been any requested at this
All
time.
right, thank you. On behalf of the people, any additional questions?
Just one more briefly. Mr. Cole, you had intended to threaten, Mr. Jennings, correct? You intended to intimidate him with the firearm?
No, I actually didn't even put it, I actually did buy the fireworks from him. I put them in my trunk. He saw the firearm. I assumed he got afraid. And-
But sir, a reasonable person, if I did that to you, you'd be afraid, wouldn't you?
Correct.
And a reasonable person would feel assaulted by that, correct?
Correct.
All right,
Then the people are satisfied, Your Honor.
Likewise.
all right, thank you. Our council where promises, threats, or inducements other than those already placed on the record.
No, Your Honor.
No, you're,
This court complied with the court rule.
You have, Your Honor.
you have your.
I find defendants pleased and freely, voluntarily, knowingly, and understanding made without undue influence, threats, coercion, or promises of leniency. Also find there are sufficient grounds to accept defendant's plea. Therefore, count 1 and 3 will enter. Count 2 is hereby dismissed. Any outstanding warrants, if any, related to this file are recalled and dismissed, and the weapon is hereby forfeited. Then let me just ask, that was your personal weapon, it was not somebody else's?
No, it was mine.
Okay, so that along with any contraband or ammunition is forfeited. Do we have a sentencing date?
June 24th at 9:30.
Same problem?
It's the same problem, and what might help the court is, my client was sentenced on April 2nd, with Judge Cunningham. He got 18 months probation, there was no jail, so he's on probation down there
I'm
now.
probably gonna run into concurrent.
Yeah, I understand that, and so I guess he'll be well into his probation if we do it in August.
Great, let's do it when we do the other one. In August.
That was August 19th.
August 19th, so that was at 9:30, let's make this at 10.
And I'm gonna tell my client to tell probation to get a hold of Eden County too.
Do you live in Eaton County?
No, I live in Ingham. No, hold on, I'm sorry. like where I live, it's like, it's kind of weird on one side of the road.
Yeah,
Eaton County and the other side of the
I'm in a
road.
neighborhood like that too.
Yeah,
Weird.
but technically, Eaton County.
Okay, so you're doing probation with Eaton County?
Yes,
Do you
sir.
want to stay doing that there?
It's always Charlotte, it's a pretty nice drive, but
Do
me and
you
the
prefer
parade,
it here?
no, I think I'll stay in Eaton County.
Okay, so let's just make a note to probation that I'm going to allow this to run concurrent with Eaton County and have them supervise.
That would be great.
Yeah,
That's what we
so
would ask
it's
for.
one-stop shopping for you, sir.
Yes, sir.
So essentially, I've already made a note to myself when I saw this, that you'll be under the same orders, there'll be just gonna be minor differences because the $68 and the crime victims, but I'm gonna run them the same. I know Judge Cunningham, I know what she does is similar to what I do, so I don't have any problems with that, but just, I know you'll remind me, but just so you know, sir, you violate there, you violate here, you're in trouble.
Yes, sir, I understand.
Okay, got
We
it.
appreciate that, Judge.
Thank
Thank you.
Can I say one more?
Yes.
My apologies to the court. So, my apologies to the court.
Oh, well. Yep, I think you're smarter than these files, sir.
Thank you.
You very, thank you, Judge.
You're good.
I'll send him down to basement
Thank you.
today.
All right.
All right.
I know we're past noon, but we only have one more left, so.
Good morning.
Keep thinking, I keep writing Tuesday and stuff Thursday, I'm like, no.
Yes.
I just had that sheet in my.
No, I just saw these.
Oh. Yes. So what happened to Sleeper?
Sleeper, the issue was that, he was not rated over, so we got a new date of May 4th, and we'll be writing him over
At what time?
at 9:30.
And did you get the new date on Blacksmith?
I apologize, that date that I just gave you was on Blacksmith.
Oh.
Sleeper is on May 1st at 2 p.m.
2, okay. Okay. Okay, what about Garcia? Sentencing?
At 11.
Was that a, HYTA? Because I don't see it.
No, it's,
Garcia is third from the bottom. We didn't do that, did we? I didn't mark
We
it
did
off.
not do it, but I don't see anyone else here, and to be quite honest, I didn't have it on my calendar, so let me see. Oh, Garcia, that was set for sentencing back on Tuesday, and and no one had appeared at that time. So you had asked for a, reset today. I did reach out to Attorney Rothstein and did not hear back from him.
Okay, well, I mean, unless we're gonna keep this in depth, this is a 21 case. I'm gonna go on the record of this right now.
okay, hold on.
This is docket 21-886 FH, people of the state of Michigan versus Gino Devontae Garcia. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
I have neither counsel nor defendant here, and off the record, people advised me that you had reached out to Mr. Rothstein, you haven't heard. This case is a 21 case, it's 5 years old. And so in order to get someone's attention and not have this out here hanging like some sort of joke, bench warrant bond forfeiture, we're going to sort it out. This has been on my schedule twice. I did this is Thursday. I called it Tuesday, gave them 2 days to appear, and no one has. So somebody better take it seriously, because I am.
Understood, Your Honor. And just to add on to what you had stated, I had emailed the email on the bar website for Mr. Rothstein, which I have as jrothstein05@gmail.com. And that email was on Tuesday, the 7th at 11:24 a.m. Mentioning this case, mentioning that the delayed sentence was set for that Tuesday, and checking to see what was happening, and told him that it was reset to today at 11 to appear and to make communication with the court, or that a bench warrant would be issued.
And do we have a current address on the defendant? Maybe I ought to notify him too. Probably there's been multiple notifications, but because it's so old, 5 years old, so we're gonna sort it out, but maybe we need to send a notice to him as well, or verify that. I'm sure he's been noticed before. I think I wrote that on Tuesday. All right, now moving on. This is docket 25-2886 FH. People of the state of Michigan versus Ahmed Bashir Sufyan. Counsel, your appearances for the record.
Good afternoon, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good afternoon, Your Honor. Mark Carter appearing on behalf of Mr. Sufyan.
Mr. Sufyan, can you unmute yourself?
Yes, ma'am.
Please raise your hand. Thank you. Please raise your right hand. Do you swear or affirm that testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. You may put your hand down. Sir, are you in the Ingham County Jail?
Yes, ma'am.
All right. And are you a U.S. citizen?
Yes, ma'am.
And have you had enough time to speak with your attorney?
Yes, I have, Your Honor.
And have you taken any medication yesterday or today?
Yes, ma'am.
Is it anything that would interfere with your ability to understand the court or your counsel?
No, Your Honor.
Is there medication you're supposed to be on that you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
All right, thank you. Counsel, what is the plea offer?
The plea offer is in file. In file 25-2886 FH. The defendant is plead guilty to count 1, domestic violence, third offense notice. The people will agree to dismiss the remaining 2 counts in that file, as well as file 25-2889 FH upon successful plea and sentence.
Is there any restitution on that other file that should be put over on this file?
Potentially, we
It
determined
looks
that.
like
in sentencing.
colonization, stalking, well, we need to make a record that he's aware of that. Stalking, malicious destruction of property, so necessarily what would be included, because if we don't say it now, then it's just gonna go away, but any restitution that's on the dismissed file would go back on this file. He's entitled to a restitution hearing. Would you agree with that, counsel?
I do.
All right, thank you. And with that said, is that full, fair, accurate, and complete?
It is. I would request that this be a plea, no contest.
And that would be based on civil liability?
Correct.
And is that acceptable with people?
No,
Okay.
this is the first I'm hearing of it. No, he got no contest plea the first time around, and he immediately did this again. Any plea he takes is a guilty plea.
He's prepared for it.
Okay. Thank you. Sir, have you heard the plea agreement? Is that full, fair, accurate, and complete?
Yes, ma'am.
All right, and counsel, you're waiving reading docket 25-2889 in its entirety, as well as counts 2 and 3 on docket 2886.
Yes.
As to count 1.
Thank you. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant for count 1, domestic violence third offense, on or about March 29th, 2025, at 614 Woodbury Avenue, Lansing, Michigan, 48906, Hamilton County, Michigan, to make an assault or assault and battery upon Aquilina, a resident or former resident of his or her household, and or an individual with whom he or she had a child in common, and or an individual with whom he or she had a dating relationship, and or his or her spouse, contrary to MCL 750812. But under the third offense notice, take notice that the defendant was previously convicted of assaulting or assaulting and battering his or her spouse, former spouse, individual with whom he or she had a dating relationship, an individual with whom he or she had a child in common, or a resident or former resident of his or her household, or knowingly assaulting pregnant individuals by violating MCL 750812 on or about 3/5/2025, and by violating MCL 750.812 on or about 3/5/2025. And therefore, upon conviction, will be subject to an enhanced sentence under MCL 750.815. There could be restitution if this offense resulted in damage to another individual's property, or physical injury or death to another individual, per MCL 780.811A. This then becomes a felony with a maximum penalty of up to 5 years and or $5,000. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed placed at confinement. The court shall order law enforcement to collect a DNA identification profiling sample before sentencing or disposition, if not taken at the time of arrest. This is against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read?
Yes, Your Honor.
So you understand domestic violence third offense, domestic violence first is a 93-day misdemeanor, second is a year, and the third gets the enhancement up to 5 years. Do you understand that?
Yes, ma'am.
And sir, looks like you signed the advice of rights form, or counsel, did you read it to him? Let me see, I don't know if I signed it. Okay, and so your attorney went over it with you, and you're satisfied with that?
Yes, ma'am.
Do you have any questions about your rights of the court?
No, Your Honor.
And you understand that because you're pleading, this is not going to be an automatic right of appeal. If you choose to appeal, you have to ask permission of the Court of Appeals to appeal?
Yes, ma'am.
And you understand that you are giving up the presumption of innocence, holding the people to their burden of beyond a reasonable doubt, the ability to cross-examine witnesses and evidence, the ability to choose to provide a defense, or to remain silent, not have your silence used against you, etc. You understand you're giving up all of that?
Yes, Your Honor.
And you chose to plead after you discussed all of your options with your attorney, is that correct?
Yes, Your Honor.
And you've been satisfied with the representation of your attorney?
Yes.
Has anyone told you what I will do at sentencing?
He probably doesn't know how to answer that. I talked to him about what our COPS agreement was, and I was just waiting to put that on.
Okay, so other than the plea agreement, no one's told you what I will do at sentencing, right?
There is no copy here.
And
Judge specifically said it's not a COPS agreement, just insight into what the thoughts are on the matter.
No.
do you need to go off the record?
Yep.
Okay. You want to approach?
Sure. So I don't know about you. No, I don't.
Ray,
I don't know. I don't know that I guarantee. Did I say it was an absolute agreement? I don't
You
really
said
do
in the exact order
this is not.
Yeah, but then you did say that. Then I said, well, you know, I have some concern about that.
The ones, yes, that is how it says this is not a conference. So I need to make that clear. Legal record, this is not a conference. I want to be worried about what you
Well,
likely to
if I
do.
don't do it, you have to
Yes.
withdraw, but it's what I like to use. I don't know.
Which is why it's.
That's why. I don't remember, when I make counts, I read it, I rarely do.
Maybe I misunderstood it, but I really remember the last one.
Okay, remind me of that. And sir, and now that we've done this, I had a, we already put those, yes.
Has anyone told you where I will do it sentencing and then other than please write on this?
Did you please?
I don't think so.
Okay, sir, your attorney and the prosecutor and I had a meeting a while back. And I told them what I'm likely to do, but it's not locked in stone. It is not a cause that locks me into stone. I do that because I don't know everything that's gone on, and I know I have multiple files, and I don't know what your behavior is gonna be, so. Do you understand that?
Yes, I do now.
Okay, and as to count one, third offense, domestic violence, how do you plead?
Can I speak to my attorney very quickly?
Sure can.
Sort of knew that was coming.
Yeah.
Mr. Barnes is your friend there, but Mr. Etheridge is not now.
Well, there's the afternoon, get after two. Tell Mr. Burns to run lunch and get after two.
This is interesting, you know, inquiring that he's planning to come back or not.
In the afternoon.
Yes, exactly.
All right. For as to count, we're back on the record, as to count one domestic violence third offense, how do you plead?
Guilty.
And
Do you have your computer in here? Can you mute it, please?
oh,
Mute
Yeah.
it, get off of.
Or your phone? You're still on Zoom.
Oh, I'm sorry.
So that's the echo.
sir, you pled of your own free will after you consulted again with counsel, correct?
Yes, Your Honor.
All right. And sir, did this offense occur on or about November 15th, 2024?
No. It's December
Oh, wait.
December 29th of 20.
Sorry, it's March 29th. I see. It's, I got it. They broke down a different. All right. Let me go back to the date. Did this occur on or about March 29th, 2025?
Yes, Your Honor.
In the city of Lansing County, Mayor, State of Michigan?
Yes, Your Honor.
At a specific location known as 1614 Woodbury Avenue?
Yes, Your Honor.
Did you come in contact with Amina Waheed, Waheed?
Yes, Your Honor.
And were you in a dating relationship with her, or were you roommates, or what happened? What's your relationship?
We were married.
You were married, okay, and you were living in the same household?
Yes. Yes, Your Honor.
And did you and she have some kind of disagreement that led to an altercation?
Sorry, can you repeat the question?
Did you and she have a disagreement that led to an altercation?
Yes, Your Honor.
What happened?
We got an argument, got kind of out of hand, and I pushed her and she fell down.
Was this done in self-defense?
No, Your Honor.
Do you know if she sustained any injuries?
I don't believe so. There wasn't any listed.
And sir, this was done out of anger. You weren't, of course, playing around, correct?
Correct, Your Honor.
And you were previously convicted of assaulting and battering your spouse, former spouse, or an individual with whom you had a dating relationship. Violating the same statute on or about March 5th, 2025.
Yes, Your Honor.
And again, on or about March 5th, 2025.
Yes, Your Honor.
And that makes this that third offense that we talked about. You understand that?
Yes, ma'am.
On behalf of the people, any additional questions?
No, Your Honor.
On behalf of your client, any additional questions?
None, Judge.
Are counsel aware of promises, threats, or inducements other than those already placed on the record?
We're not, Your Honor.
No.
Does court comply with court rule?
It has, Your Honor.
Sir, I comply with court rule.
Oh, yes.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, stress, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, count one will enter. Count two is hereby dismissed, along with count three, which is dismissed, and in its entirety, docket 25-2889 FH. However, if there's any restitution that would be placed on this file, and defendant is entitled to a restitution hearing if he so desires on all matters. Any outstanding warrants related to both files are hereby recalled and dismissed. Do we have a sentencing date?
June 24th at 9:30.
Judge, may I address the issue of bond?
Yes, after you tell me whether,
I'm
June
available.
24th at what, 9:30? Does that work?
It does.
Okay. As to bond.
Judge, as the court is aware, the sentencing date is pretty close to 3 months away from today. My client has already served over a year in the Ingham County Jail. He had, before he went to jail, he was suffering from digestive ulcerative, thank you, that colitis. He was on medications at the time he was taken to the jail. His dad is a physician. His father notified the jail of that probably 2 or 3 months ago because he was having all kinds of problems. In response to that notification from his dad, the jail did take him over to a doctor, but the doctor never saw him. And then they never scheduled an appointment for him. About a month ago, I sent notice to the jail regarding his physical condition. They did take him to a doctor. The doctor apparently ordered that he prescribe specific medications to address his issue. Even though it's been 2 or 3 weeks, according to what I'm being told, since he saw the doctor, he's still not receiving whatever that medication was that was ordered. In addition to that, with regard to bond, I would indicate to the court that while he's spent over a year in prison, in jail already, he's completed the jail's ACCI Domestic Violence Awareness course. That's an 8-week course. He's also done dialectic behavioral therapy, which I'm told is a 12-week course. He also did the jail's cognitive awareness and domestic violence program. And he also did an anger management course, which I'm told is 12 weeks. He also participated in the jail's RJI pilot program, and as part of the report on that, they reported that my client's participation has been courageous and transformative. And that included both group sessions and weekly individual sessions. I would also indicate to the court that my client graduated with honors from Hazlitt High School. He attended early college before he graduated from high school. At LCC, where he graduated cum laude with 2 associate's degrees at the age of 18. He graduated from Western Michigan cum laude in biomedical sciences and a minor in chemistry. He was actually set to enroll at Central Michigan to be a physician's assistant, but getting arrested in this case kind of put a blockade up on that issue. And that he's also a certified medical assistant. Given that he's already been in jail for over a year, given the medical attention he has not been receiving, though should have been while he's in jail, and given the courses that he's already taken while he's in the jail, I would ask the court to reduce his bond to a personal bond, so he's not sitting in jail for the next nearly 3 months. And I would also ask the court to take into account, well, I'll just leave it at that.
Well, let me ask you this, will he be, I have an address of the 1561 Tagalake Trail, is that where he'll be residing?
That's his dad's house, yes.
So he'll reside with his parents or his dad, or?
Yes.
Okay, and then, what's the state of the marriage?
They're going through divorce proceedings.
And there's a minor child?
There is.
And so has a friend of the court or the judge, the family court judge addressed that?
That I couldn't say.
All right.
What I would also say, Judge, if I might, he knows without a doubt that if you grant my request, that if he violates any bond condition, that I'll just be very plain, he knows you're going to hammer him. And he will have that in the back of his mind every time he walks out the door and does anything while he's continuing on bond or on probation to you. So with that all in mind, and given the fact that he's already done over a year, I would ask the court to grant my motion.
Response?
That's what he and his attorney said, his first attorney said in the first round of all of this, that he knows he violates the no contact order, that you'll hammer him, that he won't disobey the court orders, and then he just admitted they were living together in violation of the protection orders.
In an apartment that his wife rented for him.
Yup, because he kept contacting her over and over. I didn't see the first case, so he had witness interference charges the first time around, and he was trying to stop her from going to court this time, which is why we had witness interference charges this time around. He was telling her, don't answer their subpoenas, don't come to court, don't respond to anything they do.
That's not what she said.
Every time that he's been released, he has been violating the orders of the court. He had
He never-
8 PA 53 violations the first round of all of this. You had to tell him, once you had released him, quit stalking his pre-trial release agent. He violated your probation within 38 days. I believe it's appropriate that he be kept in there until his sentencing hearing. I don't believe bond should be lowered now that he's pled guilty before that hearing.
And he had never spent a year in jail prior to any of those events occurring, knowing what could happen if he violates. And now knowing not only could he be sentenced to a jail term, he could be sentenced to a prison term. That puts his state of mind in a whole different place than it was previously.
Sounds like he's out of jail time.
Pardon me?
Sounds like he's out of jail time.
He
It
is.
would be prison.
Right.
Sir, do you understand that if I release you, there's no contact? It means no contact, and I will send you to prison, and I don't care who your daddy is, and I don't care what your excuses are. No contact means no contact. So we'll have a hearing, and your attorney's gonna do his, his best, but he can only do so much magic when you don't give him any reason really to have evidence that supports you, because the evidence is so far has been weighted on the side of the people because of your own acts, and your attorney's not a magician. He can't undo your acts. So do you understand that this is all on you?
Yes, ma'am. I completely understand. Like my attorney said, I've been in jail for over a year. I think before I kind of took it for granted. I will not make the same mistake twice.
Well, sir, I have a pile. Today, you get the blue ribbon in first place for the biggest pile on my desk. There's 3 of them, and they're filled with information about you, sir. See all this? It's all you.
Yes, ma'am.
So tell me about the divorce. Are you actually getting divorced?
Yes, ma'am. That's completely my intention. I haven't been able to like follow up from the jail.
Did she file?
Ma'am.
I didn't hear the answer.
What did you say, sir? You don't know, or what?
Yes, ma'am. She filed, and so far I've been waiting for like the finalization for it, but that's completely my intention to follow through with that.
All right, so I'm gonna give you a $25,000 PR bond. You will really make me unhappy if the prosecutor says, "I told you so, Judge," and he will. And I'm going to just remind you, you're out of jail time.
Yes, ma'am.
You will have made a record here with your behavior that the appellate court will uphold me for sending you to prison, because we got a whole lot of background here that says you can't comply. So I hope that you truly learned and are rehabilitated with all that treatment in jail. There's a lot more treatment in prison if that's what we need to do. Have I made myself clear?
Completely clear, Your Honor. Yes, ma'am.
You are going to be placed on a jail GPS tether. You will not be within 1,000 feet of Amina Wahid or your child until it's all sorted out at sentencing and with the family court. And I make sure that there's a trained therapist who says that you can behave yourself. You're not going to be with a child.
There's a judge in the divorce center on 3-4.
2 children, Your Honor.
2 children. Okay, what?
There's a judge in the divorce center on 3-4.
Oh, apparently, I was just advised that on March 4th, there was a judgment of divorce entered, so congratulations, sir. I don't know what the terms of that are, and in regard to your children, I suspect there's probably supervised or no parenting time until you complete whatever, so we'll have to take a look at that. But until I say so, I trumped the family court, so we'll see what that says and what the treatment recommendation is and all of that as it pertains to your children as we go forward here. You shall not use, possess, consume, purchase, or be in the presence of any illegal drugs, alcohol, or drug paraphernalia. You'll show any prescriptions for medications from a licensed medical physician to pretrial services within 24 hours. Take any psychotropic medication as prescribed, if any, and follow all doctor's recommendations. You will PBT and or be drug tested as requested by pretrial services, law enforcement, any court officer, your father, or a friend of the court. You will not own, have in your possession, or under your control any weapon, gun, ammunition, or imitation of a weapon, or be in the presence of anyone who has these items. You will not be in the presence of any known gang members. You'll not wear any gang colors, gang insignia, or gang tattoos. You'll maintain your residence, and that's with your father. Any address change will be reported to pretrial services, the court, and counsel within 24 hours and needs court approval. You'll appear for all hearings and proceedings. Your sentencing is June 24th at 9:30 a.m. You'll follow all family court orders and all laws. And I was just handed a note that as to the judgment of divorce, your ex-wife has sole physical and sole legal custody. However, you can have supervised parenting time upon termination of any personal protection order there may be, or no contact order. Right now, there's a no contact order. So we'll address that at a later time, counsel.
If that order from family court gets amended to some kind of limited contact between now and the 24th, would you then under your bond? No.
Still needs my permission because I trump them no matter what they write.
No, I
But
get
if
that.
I'm amended, then I will let them know.
I guess my question was, is could I file a motion, given new information, to see if you would grant him comparable visitation?
You can, however, I need to see from a trained therapist that it's in everybody's best interest that happened, because I know that you said he's gone through a lot of treatment. I don't have the documentation of that. I don't know how well he's doing. I suggest that when he's out, he gets back into treatment with community mental health, or his dad's a doctor, with whoever they want to treat with, so that we keep him in line, because if this happens again, he's got a lot to lose.
Understood, Judge. Thank you.
So I have to rely on experts for that, counsel, as you know. Mr. Pfeiffer, is there anything I have not addressed here?
I believe you've addressed everything on this file, Your Honor.
Okay, so are we clear? Because you haven't been in the past about what no contact means. No contact means no letters, Hallmark cards, flowers, smoke signals, carrier pigeon. You don't live with her. You don't go on the same street with her. You're going to be 1,000 feet away from her. 1,000 feet away from her and your children.
Yes,
Their
sir.
residence, school, place of employment. Until further order of the court. Are you clear on that?
Yes, ma'am.
Any questions?
No, Your Honor, not for me.
All right, now I know you've got other files, so you know what I'm gonna say next, but I'm gonna remind you. Within, well, today's Thursday, so I'm gonna say by Monday, because I don't know when you actually get processed. It could be today, it could be tomorrow morning, I don't run the jail. But by Monday, you're going to be back in this building, or you make a phone call and you make and keep an appointment with probation so they can do the pre-sentence investigation report, because I can't go to sentencing without it. If you do not do that, I have a standing bench warrant for everybody who fails to appear for that. You'll be picked up and sit in jail until sentencing.
I'll make sure to do that.
Counsel?
Judge, for whatever my thoughts are worth, my experience, I don't have a lot of experience here in Ingham County, but in many other counties, since you're asking them to be on a tether, which we have no objection to, sometimes it takes more than a couple of days to get put on the tether.
The jail GPS tether should be right away.
Okay,
Cause or the jail, when they got them there, they should be doing it. And it could if they run out, there are those circumstances, but it's the jail GPS telling he's not gonna leave without it.
No, I understand that, but will they get it on him by Monday? That's my
They're
concern.
gonna get him on before he leaves.
No, I understand that, but if they're not gonna release him until he gets it on.
Right.
So if they don't put it on him until Tuesday or Wednesday of next week, I don't want him to be in violation of your order.
No, he won't. He
Okay.
won't be, because he'll have to, they won't release him without it. They're probably gonna release him today or tomorrow on it, because it costs the county a lot of
That's
money.
fine.
So, and then he'll go to, make an appointment with pretrial services, he can even make a phone call, but, and if for some reason he's not released till Monday, it'd be 24 hours after that, 24 hours and so forth. So
Thank you.
I use a reasonableness yardstick with that, because I get it, the county, I have no control over every department, wish I did.
Got it.
All right, we're gonna make sure y'all get copies of this. Any questions, sir?
No, ma'am.
All right, and all files will be set in front of me at sentencing.
Understood.
Understood, thank you,
Thank you, Judge.
thank you. Mhm.